Good morning. Now we've got a full house. I want to make sure everybody has a chance to grab a place to sit, grab a seat. I did, thank you. Glad to have you all before our 6th meeting of the Interim Joint Committee on Judiciary. We've got a packed agenda, so we're going to jump right in right after we call the roll.
Senator Berg, Senator Carroll, Senator Deneen, Senator Neal, Senator Schickel, Senator Stivers, Senator Storm, Senator Turner,
Here.
Senator Wheeler,
Here.
Representative Banta,
Present.
Representative Blanton,
Here.
Representative Bratcher, Representative Bray, Representative Burke,
Here.
Representative Decker,
Present.
Representative Dietz,
Here.
Representative Flannery,
Here.
Representative Herron, Representative Kulkarni, Representative Lewis,
Here.
Representative Maddox, Representative Mosier,
I'm here.
Representative Nenas,
Here.
Representative Petrie,
Here.
Representative Rawlings,
Here.
Representative Sharp, Representative Stevenson, Representative Wilson, Co-Chair Westerfeld,
Here.
Co-Chair Elliott.
All right, thank you. We do have a quorum, and we're authorized to do a little business today. Does anybody have any guests they want to recognize? Chairman.
Thank you, Mr. Chairman. I'm honored to have the Honorable Bruce Petrie with us this morning from the 50th Judicial Circuit, my family court judge. So thank you for being here, Judge Petrie.
Welcome. Glad to have you here. Also want to recognize the newest member of the best team in all of LRC. That would be the Judiciary Committee, John, if you're listening, in transportation. That is Stephanie Larkin, the new analyst with the Judiciary Committee staff. Welcome, Stephanie. Glad to have you here. Welcome to the meat grinder that is this committee. All right. With that, I'll take a motion to entertain, or I'll entertain a motion to approve the minutes of our October meeting. Got a motion from Representative Moser, second from someone. Any questions, any adjustments, edits, corrections? Seeing none, all those in favor, please vote by saying aye. Aye. Those opposed? Minutes are approved. All right. I can't take credit for this. I'm pretty sure it was John Great that suggested it to me way back in 2013, my first year here. And we invited the Chief Justice of the Kentucky Supreme Court to appear before this committee to provide a sort of a State of the Court's address, and I made it an annual affair. And I think it's been really helpful, not just for the court, but for this body and for the legislature to hear the court is operating and what its initiatives or priorities are. And so I certainly was happy to extend the invitation. We were happy to extend the invitation to Chief Justice Lawrence Van Meter. And we're glad to have you, Chief, this morning. The floor is yours. Make sure your mic is on. Is the green button lit? Touch the...
There we go.
Now you're hot. All right.
So anyway, my special guest, I think I have the entire judicial branch behind me. So anyway, Chairman Westerfield, Chairman Elliott, members of the Judiciary Committee, and guests. I have the privilege and honor to be here today to deliver my inaugural State of the Judiciary address. The Interim Joint Committee on Judiciary has a long-standing tradition, as noted, of inviting the Chief Justice to deliver this report to update committee members on matters of significant relevance to the judicial branch. The timing is appropriate as you and your fellow legislators prepare for the fast-approaching 2024 regular session of the General Assembly. During my investiture in January, I pledged to the legislative branch to safeguard the judiciary's independence but exercise sound and nonpartisan judgment when called upon. Although some level of tension between the branches of government is inherent, I believe I've remained faithful to that pledge. This may be my sole State of the Judiciary address, as I'm not pursuing re-election for another term. The moment has arrived for me to embark on a new chapter after 30 years of judicial service and let someone else have this opportunity. While change within any government branch can be at times a challenging process, I'm dedicated to ensuring that the upcoming transition is as smooth as possible. My colleagues and I are committed to the ongoing evolution and transformation of the court system to address the requirements of judges, circuit court clerks, court employees, attorneys, and citizens throughout the Commonwealth. Now, I'll begin by addressing some topics. The first one has to do with pay parity. I extend my gratitude to the General Assembly for the raises we've received in the past 2 years, and although we've made substantial progress in retention and recruitment, we still lag in compensation compared to the other branches, which is why we are requesting an additional increase. Kentucky has slightly climbed in national rankings, but the Commonwealth's judges and justices earn $24,000 to $32,000 below the national average, depending on the level of court. The quality and viability of the state's judiciary depends on erasing that wage gap. The disparity in compensation also extends to our circuit court clerks, with a salary difference for comparable roles ranging from $7,200 in Kentucky's smallest counties to nearly $15,000 in urban areas. Our non-elected workforce faces similar challenges, with salaries falling short compared to their counterparts in the executive branch. This results in high turnover rates as these employees seek higher paying opportunities in both state agencies and private sector. The legislature's support has been critical in helping improve judicial branch compensation, and we are very thankful for that. Now we must continue the work of erasing the wage gap. With respect to our external audit results, I'm pleased to announce that for the third consecutive year, the judicial branch has received an unblemished audit opinion on its financial statements from an impartial third-party auditor. This reputable firm examined the financial records of the Administrative Office of the Courts and determined that the judicial branch's fiscal year 2023 financial statements were free of material misstatements, contained no material audit findings, and were in accordance with accounting practices under state law. This external audit is one of the many steps we've taken in the judicial branch to increase accountability and ensure good stewardship of taxpayer money. In 2019, the AOC restructured its organization to align its administrative and financial operations with industry best practices. We established the Independent Audit Office of Audits, which is comprised of the divisions of internal audits and audit services. And we also, I'll mention, we hired Alice Wilson from the executive branch, and we call her the most feared woman in the judicial branch. Statewide programs. State courts have increasingly become the place for addressing the needs of those with substance use disorders and behavioral health issues, and the Office of Statewide Programs has several departments to respond to those needs. In cases where individuals lack access to essential social services, the response often involves law enforcement and the justice system. This results in far-reaching and long-lasting consequences. The continued criminalization of these disorders and health issues have devastating effects on families, individuals, and society. The Supreme Court has recently revised its rules to strengthen drug courts across Kentucky. The revision encourages best practices and standardizes operations. It also establishes a certification process for adult drug courts that adheres to those practices and standards. 9 pilot sites were selected to undergo certification ahead of statewide implementation. The pilot counties are Campbell, Clark, Davis, Fayette, Hardin, Jefferson, Johnson, McCracken, and Pulaski. Through collaboration with Kentucky Judicial Commission on Mental Health, Specialty Courts is committed to expanding mental health courts. The department is seeking funding opportunities through federal grants to expand mental health courts for 5 additional locations. We are hopeful the legislature will consider a budget expansion that would support more staff positions, treatment funds, and general operating costs for 10 additional courts. Our pretrial services department is the process of reevaluating its risk assessment tool known as the Public Safety Assessment. The revalidation process will either validate that the PSA is accurately predicting risk scores for failure to appear in new criminal activity, or make recommendations for necessary adjustments to the tool to accurately predict the risk factors. The implementation of Senate Bill 90, the Behavioral Health Conditional Dismissal Program, is underway in 7 of 11 pilot counties. We anticipate that the remaining counties will begin implementation by the end of the year. And you'll hear much more in a separate presentation on Senate Bill 90 following my address this morning. The Family and Juvenile Services Department oversees two programs required by statute to provide services statewide. Those are the Court Designated Worker Program and the Citizen Foster Care Review Board. The Citizen Foster Care Review Board provides direct service to judges by supplying findings and recommendations to the court on every child reviewed by local boards. The intent is to provide services for children while they are in foster care and to get them into permanent homes in a timely manner. Spanning all 120 counties, we're proud to have about 750 volunteers serving on 170 boards. In fiscal year 2022, a total of over 21,000 reviews were conducted for almost 13,000 children in foster care. As you may recall, the 2018 Child Welfare Reform Bill, House Bill 1, introduced an additional role for our Citizens Foster Care Review Boards, volunteers. These devoted individuals now host biennial regional community forums. The gatherings offer the public an opportunity to discuss their concerns regarding Kentucky's foster care system and identify any barriers to ensuring the safety, well-being, and timely permanency of children in and out of home care. The insights gathered from these forums are incorporated into the Foster Care Review Board's annual report and shared with the Supreme Court, the Governor, and the Legislative Research Commission. The Kentucky Commission on Mental Health. The Department of Specialty Courts, Pretrial Services, and Family and Juvenile Services all provide support staff to the Kentucky Judicial Commission on Mental Health. Deputy Chief Justice Deborah Hembry Lambert and Program Director Shauna Mitchell will provide more information about the Commission's groundbreaking work following my address, and we give many, many thanks to them for their significant efforts to lead this initiative. So I'm now going to talk about court facilities, and we cannot accomplish all the great work I've discussed without court facilities to meet today's needs. So let's provide some insights into a critical aspect of our work related to court facilities and the need for a new construction project in Owsley County. First, we are committed to maintaining safe and viable court facilities. State law requires the AOC to assess our court buildings. In addition to seeing if the facility is ADA compliant and up to modern building codes, professional architects examine age, safety, plumbing, electrical, and mechanical conditions. An independent third-party architect has conducted assessments of 37 counties that have not undergone any new construction or had any renovations authorized by the General Assembly since 1996. Some of these counties, like Owsley, have never had a judicial center project. We plan to assess an additional 35 counties in the next biennium. The assessments are based on a scoring system ranging from 0 to 100, with 100 indicating a building in new condition that fully meets the needs of the KCOJ. Buildings scoring below 40 are deemed to be in critical need. Owsley County Courthouse has a ranking of 31.97, placing it first or last, depending on your point of view, in that critical need category. This designation is due to various issues, including poor plumbing and HVAC systems, deteriorating electrical systems, security concerns, ADA compliance deficiencies, inadequate courtrooms, and a deteriorating roof. Given the critical state of Owsley County's courthouse, we are requesting the construction of a new 24,000 square foot facility. The design program for the proposed project reflects the scaled down construction requirements adopted by the Judicial Branch in 2018. Under these scaled down requirements, 24,000 square feet is the smallest court facility that will meet the Judicial Branch's needs. The estimated cost for this project is $28 million, with a maximum authorized use allowance of $2.3 million. Court of Justice capital construction projects like Owsley are unique in that they are locally bonded, meaning the county owns and finances the project, but the General Assembly appropriates a use allowance to the AOC, which covers the debt service. This arrangement ensures that these projects do not count against a county's debt capacity. I also need to discuss 3 previously authorized projects in Butler, Clinton, and Crittenden counties. Our judicial branch construction projects are different than the executive branch building plans. Because our projects are partnerships with local governments instead of being solely state projects, we request legislative authorization for these projects before land acquisition and design costs are incurred, and about 3 to 4 years before bids are let. This timeline leaves us particularly vulnerable to rapidly rising construction costs. In 2020, the AOC used a $400 per square foot estimate for capital construction projects. However, we have witnessed these estimates jump to $750 per square foot due to the increases in costs for building materials and property. Recognizing this challenge, we requested an additional use allowance last year to cover the difference. The General Assembly appropriated part of that request by extending the bonds to 25-year term. In conjunction with the increased use allowance, we were able to proceed with projects in Barron, Bath, Graves, Jessamine, Leslie, Madison, Oldham, and Scott counties. However, despite the increased use allowance authorized last year, we find ourselves unable to proceed with the Butler, Clinton, and Crittenden projects, all of which were authorized by the 2020 General Assembly. Therefore, we are requesting $1.4 million in additional annual use allowance to move forward with these 3 projects. This request would allow us to proceed with a 20-year bond term. In addition to the courthouse and judicial center needs in each county, the Court of Appeals needs a permanent home here in Frankfort. The appeals court has had to move out of its location of 29 years after water leaks created a hazardous mold problem and the property owner filed for bankruptcy. The Court of Appeals relocated to a temporary space in August, but the cost of the move and the new lease is considerable. The rent is $337,375 annually. The judicial branch is requesting general funds to construct a 17,000 square foot Court of Appeals building. An estimated $14 million is needed, although through either a one-time appropriation or bonds. Since the new building will be constructed on the Vandelay property adjacent to AOC headquarters, we don't need any additional money to buy the land where the new building will be located. The next issue is our maintenance pools. So let's look into the maintenance of facilities. The judicial branch occupies a substantial 5.4 million square feet of space across the state, primarily in court facilities owned by counties and used by the Kentucky Court of Justice. By law, the AOC is responsible for covering the operating costs of these facilities, including maintenance, repairs, and general upkeep. Additionally, the AOC pays for judicial branch's proportional share of all bonds issued to construct or renovate products authorized by the General Assembly. Over the years, the Commonwealth has made significant improvements in court facilities, authorizing capital projects for 105 court facilities since 1990. However, 15 court facilities have remained substantially unchanged since before the judicial article was passed in 1976, and another 52 have not had projects authorized in this century. The functionality of some of these older court facilities can be preserved by replacing key building components. The challenge we face in the Court of Justice current maintenance allocation, which stands at $4.6 million, or approximately 85 cents per square foot annually. This allocation only covers minor repairs and is insufficient to fund major replacements of vital building components such as roofs, HVAC, and electrical systems. The replacement of such component typically costs more than $1 million per project and requires the General Assembly authorization as capital projects. This limitation has impacted the AOC's ability to address system failures even when judicial branch funds are available to support the project. To protect the significant investments made in these court facilities across the state, we will be requesting 4 capital projects for asset preservations. These include a maintenance pool for HVAC, roofs, electrical components, and small miscellaneous repairs and renovations required in specific facilities. This request is made more urgent by the fact that many building components in court facilities authorized by the General Assembly reach the end of their life expectancy after 20 years. While we are committed to building maintenance cost into future requests, additional funding is needed to preserve the assets that have already been authorized over the past 3 decades. The AOC is therefore seeking $53.5 million in general fund projects, which will be used to facilitate the replacement of about 20 roofs, 30 HVACs, 25 electrical systems, and several capital renovation projects in Jefferson, Kenton, and Warren counties. With respect to the capital renovation, we are aware that the Capitol is undergoing an extensive top-to-bottom renovation, In connection with this project, the Supreme Court has been advised of the need to relocate at some point in the next year, likely in the spring. While the Supreme Court offices will temporarily be in the building where the Court of Appeals moved this past summer, the AOC is collaborating with the Kentucky Historical Society to secure additional space in the old Capitol. And remarkably, this will be the first time that Kentucky courts have utilized this historic space since June 1909. Moving now to technology, e-filing, and e-orders. The concept of e-courts in Kentucky was initiated in 2010 when former Chief Justice Minton articulated a vision to, quote, fundamentally change the practice of law in Kentucky, unquote. In 2013, the Supreme Court approved the electronic filing pilot project. It eventually expanded statewide, and since October 2015, electronic filing has been available in every county. Circuit court clerks process between 120,000 and 140,000 e-filing submittals every month, and 6 million e-filing submittals have been processed since the program's inception. As we witness growing adoption and acceptance, and to facilitate the eventual goal of an electronic case record, the court gradually began mandating electronic filing for attorneys in specific case types starting in 2022. That list has continued to expand, and as of December 1st, attorneys will be required to electronically file documents covering 40 different case types. The Supreme Court also took the next step towards the creating of an electronic case record by mandating that judges electronically enter orders in all case types in which attorneys are required to e-file, subject to certain limitations, and that will be effective March 1st, 2024. This change is a significant one for how many of our judges conduct business. To help the transition, the AOC and the District and Circuit Judges Education Committees are facilitating individual and group training for judges and their support staff. In 2022, the General Assembly provided $38 million from the American Rescue Plan Act to replace our 2-decade-old case management system. It will enable us to move our courts into the era of electronic court records. Our strategy involves potentially transitioning to a vendor-provided solution following the successful lead of other states. Recognizing the ongoing challenge of attracting and retaining technical talent in Kentucky, coupled with the inherent turnover within that industry, we believe that a vendor-provided solution might offer a more sustainable path forward, which we plan to release. Well, we're in the process of developing a request for proposal, which we will plan to release in January. So we anticipate a new case management system will achieve greater efficiencies, enhance access, and ensure a more sustainable future for our courts. So as we look ahead to the future of state courts and the legal profession, two issues have emerged as the most urgent for us to address. The first relates to the shortage of attorneys in rural communities, which is concerning both from an access to justice and a sustainability perspective. 29 counties have 10 or fewer practicing attorneys, and 7 counties, Robertson, Carlisle, Elliott, Lee, McLean, Menifee, and Owsley, have less than 5 practicing attorneys. This shortage in available representation results in a limited pool of candidates to seek election when vacancies occur in judicial offices or the offices of Commonwealth or county attorney. The Kentucky Bar Association recently formed a rural practice task force to investigate issues impacting the rural practice of law in Kentucky. The second issue relates to artificial intelligence and its impact on both the operation of the courts and the practice of law. Artificial intelligence, or AI, is not new and is already being used in other state courts in limited ways. You can find chatbots providing customer assistance by simulating human conversation in some states. But the evolution of generative AI, such as ChatGPT, raises new issues and concerns about how this technology is used in our courtrooms. A handful of state courts have established orders regarding the use of AI, placing the burden on the attorney to notify the court if he uses technology in drafting of court filings and to confirm the accuracy of the information generated by it. We recognize that this soon will be an issue of Kentucky courts if it's not already. To that end, the KBA has established an AI task force chaired by former Chief Justice Minton. The purpose of the task force is to address the ethical and professional risks that come with using AI, along with recommendations regarding how these fast-evolving technologies can or should be used by attorneys. So in conclusion, and as I conclude my address, I wish to pause for a moment to acknowledge the extraordinary individuals who diligently uphold the operations of the judicial branch, all the while adapting to the winds of change. Over the course of my nearly 3 decades in the judiciary, where I've served as a judge at every level and as a Supreme Court Justice and now the Chief Justice, I've had the privilege of forming lasting bonds with dedicated professionals who have committed their lives to the cause of public service and to the judiciary. So again, I extend my gratitude to each of you again for allowing me to share the remarkable work undertaken by the judicial branch, and I'm happy to answer any questions. Thank you.
Chief, thank you so much. As always, I'm grateful for your leadership, and I appreciate you giving time this morning to the legislature to share a great wealth of updates about the court system. I've got a couple of questions, and there's already a list growing here, so we're going to get to those. I'm going to save the mental health questions for your colleague in the next panel with Justice Lambert. But on the facilities question, I mean, I spent time as a practitioner in Butler and Crittenden with some frequency, and I've been to Clinton County's courthouse and seen their facilities. I don't know that I've seen an assessment on which one of those is worse than the other, but can you give me the price tag for that again? There was an additional amount that you asked for to cover those to make sure that they got in there. Okay. I can speak. I can't break those down. Sure. But I can say for sure that I can say with my own eyes I've seen all three, and they are all three in need. Do you happen to know how many courthouses around the state, or Katie, are not presently ADA compliant? Just off the top of your head?
I'm looking back to the people who would know, and I don't think off the top of our head we do know. That is probably information we can work on providing, though.
Okay, thank you. I also wanted to ask about Graves County, and I've heard from Director Comstock that the paper records have been rehabilitated, that you're still working on digitizing those records. What's the status of the facility, that project there, and how are things working with the location that they've got temporarily?
Rhodes would be the...
For that, is it okay if we phone a friend and
certainly.
have some people come up?
Certainly.
Okay.
And he would know.
Ask for a lifeline.
Yes.
See, when you come to Judiciary, you never know. Judge Cutoff, you're next.
That's why we bring everybody.
Good morning.
Yes, sir.
My name's Danny Rhodes. I'm the Executive Officer of the Department of Court Facilities at AOC.
How are things in Graves County?
Graves County is doing well. We have moved into a private sector lease. It's basically a renovated shopping center, strip mall. We have been able to provide space for both district and circuit court, as well as our circuit court clerk, drug court pretrial, and CDW. CDW is in a different location than the other court representatives. So we have met all of the needs of the current judiciary there in Graves County.
And the status of that project for a new build, I don't know where you all are in the, I know it's a multi-year effort, I just don't know where you are in the process.
We have just entered into a contract with the project architect. We have identified approximately 3 parcels that would be potential locations for the new judicial center in Graves County.
So you won't keep it in the middle of town?
We are trying to, as part of the assessment of those parcels that were basically 2 of which were presented to us as potential offers. One was identified by the PDB, the Project Development Board. All of those are within 2 blocks of the historic courthouse site. So,
and to ask a dumb question, you've got Graves County people participating in those decisions, I assume?
Correct.
Okay.
Correct.
Let me just say something real quick about Graves County. So when I was down in that area. I'm like, okay, I'm going to drive through Mayfield. So I put my app on how do I get to Graves County Courthouse, and it told me it was there, and I'm like, it was a field. I mean, all of downtown, in case any of the committee members don't know, I mean, that tornado just wiped out downtown. So then when I was trying to leave town to get back on the Purchase Parkway, it said, okay, go to the, go left to the next light. I'm like, there are no traffic lights. It took out everything. So
It did.
I will add that the site of the historic courthouse that was raised, because of the tornado, the intent for that site is that the county administration building will go back to in that location.
I got you.
They were basically, it was an addition to the historic courthouse. That was where their previous location was. So they have decided to go back on that site.
My next question, and then I'll hand the floor over to some other legislators here. On the technology side, and I've had conversations, Director, with you regarding the Vine system. We had testimony last month on Vine. Can you give us an update on what's happened since last month?
Yes, absolutely. We heard your all's concerns. We started meeting with APRIS, which is the vendor that controls Vine. In fact, we had our first meeting a few weeks ago. We're talking through possible options, and we're learning. One of the questions you'd actually posed to me, which I didn't know till I spoke with them, is how many states use their Vine Court Notify system, and there's 13 states that currently use that. Also, to let you know and be fully transparent, we got an initial estimate from them actually yesterday, and the initial estimate is about $1 million with $500,000 annual maintenance costs. So again, this is something, and we heard your all's concerns. We're having those meetings, but fully transparent. That's not something in our current budget request, but we're continuing to meet because who knows? As we talk through things, maybe the price we can get it down, but as for what they sent us yesterday, it was $1 million.
Thank you for that. I just want to encourage you to keep those conversations going. Having those victim notification services is a really big priority, I think, across party line here with the legislature, and the testimony and the commentary we heard last month shows that. So I hope you all stay on that is on the front burner for the court system, along with 100 other things that are on your front burner. But I want to make sure victim notification services continue to get attention.
And I'll also give plug for our friends at PAC who are seeking funding to get a case management system. They could also, the more they have that and our systems can talk to each other.
That last bit is the most important thing. If they do that and you all have your case management operating system or whatever, your service put together, it would be really nice if they communicated mainly from a data perspective for the policymakers that come after us. It'd be nice to know we can rely on the information we get.
Absolutely. The dream would be DPA already has a case management system. It's the prosecutors are the only ones who don't. So if we all three could get one that talk to each other, that's really like the wave of the future. And imagine all the data we could produce.
There's a joke in there about how DPA has something, everybody else doesn't, but I'm not going to make it. All right. Representative Nemes.
Thank you, Mr. Chairman. Thank you, Mr. Chief Justice. Want to note, Justice Lambert is in the crowd. But I'm very happy that she's here supporting you today. Chief Justice Thompson's over here, and thank you. I look forward to working for the Tom Emberton Court of Appeals this coming session. John Myers, the head of KBA, is in the audience. KBA does a wonderful, wonderful job. I won't say too much about me thinking that it's wrong that this is the only profession you have to be a member of an organization to put food on the table, but that is in no way an attack on, which is true. It's the only one in the whole state. But the KBA does a great job, and I wanted to make sure that I mentioned that. AOC with Katie Comstock, she's doing a wonderful job. We all have a lot of faith in her, trust in her up here. Had a problem with the issue that we've just talked about for a long time. She comes in immediately and gets on it. So I want to honor that as well. With respect to the facilities, the man sitting next to you, there's no better ambassador for the court system than Danny Rhodes. You talk to local officials throughout the Commonwealth, and they have a lot of trust and faith in him. And so you've got really good staff at the AOC, and so I want to make sure that we're honoring all of those things. With respect to judicial raises, I want to note that a lot of that work has been done by Patrick Flannery up here. He's in charge of our budget, our judicial budget, and he's worked very hard to improve the pay of judges. In 2008, the judges in Kentucky, I think, were 17th in the country, and now they're in the low 40s. And so we've had a lot of of regress there, and we need to make steps to bring the judges' pay back where it needs to be. And Patrick Flannery has done a lot on that, and he's our leader in the House on that score. I do need to ask one question for the constituents that I represent in Jefferson County, and that is this. Let me build it up, and then I'll ask the question. And that is, trial commissioners under the Constitution are required in places where there are no, in counties where there's no district judge that resides. If there is a district judge that resides in a county, then we can have a trial commissioner, and that's the prerogative of the Court of Justice. We have 17 district judges in Jefferson County. And the reason that we have trial commissioners is so there can be calls, important calls from law enforcement and so forth, when the judge is in, let's say, Trigg County, when there's an issue in Lyon County. In Jefferson County, though, we have 17 district judges, yet we are paying trial commissioners to do the job. Let me finish. The problem with that is when something goes wrong, and it does frequently in Jefferson County, and it has very recently with a death on the line, there's no judge to hold accountable. That is not appropriate. We've put in the budget last year, Section 3, Part 9, that no general fund dollar, no Court of Justice appropriated dollar is to go to trial commissioners. But the Court of Justice decided to break the law and not follow that. So I want a commitment from you. That was not your doing. But I want a commitment from you that you're going to follow the budget and that we're not going to be paying trial commissioners appropriated dollars anymore as the law prohibits.
So there's a lot of packed into your comment and your question.
We can have a back and forth if you want to.
Well, okay. So we just got notification within the last day or so that Judge Williams has announced her retirement. So we're now going to be down to 16. Which is
if they would have to that's less than once per 2 weeks.
No, I know that, but I'm just saying
to take night calls.
That Judge Williams has announced her retirement for health reasons.
Understood.
So we're sad
so we're down to
about
16.
We're down to 16. They just the other day sent me a letter again expressing the need for the 2 trial commissioners that they have. So the district judges down there are now going to be taking all the bond calls, I believe. Is that correct?
Starting November 15th, the district judges are going to start taking those bond calls back. But we would be remiss if we didn't say in Jefferson County, the judges have a rotating basis 7 days a week, and they take bond calls right now at both noon and then 9 p.m. But in addition, they've also discussed, and the term has discussed, that starting November 15th, that they're also going to do that 6 a.m. bond call. Yeah. So the trial commissioner...
And my judge in Oldham County does it every night, not once every 16 nights.
So one more thing is that you and I talked about this last week in the hallway, is that I have directed Carol Henderson that we're now going to, if we're going to have trial commissioners, and it's not just Jefferson County, we also have them in Perry, Fayette, and Christian, with respect to, because of the mental health issues and the mental health facilities in those counties, that we will pay those out of restricted agency funds.
That follows the law, and thank you, Mr. Chief Justice. That hadn't been followed in 2 years, and I didn't know it until someone got out that shouldn't have got out. I appreciate you doing that.
Which I can't comment on.
I'm not asking you to comment on that. I want to end on a good note. I do think the Court of Justice does a lot of great things. It's the gem of our Constitution, I believe. But when
I read a book on that.
That's right.
It was a small book, but it's really, really outstanding.
It was outstanding. But when things go poorly, it's our responsibility. That you just knocked out one of our bills last week, so there's a healthy tension there, and I appreciate that.
I can refer to that opinion, and that's all I can do with that, because as Judge Gudgel told me, judges speak by their opinions and orders, in no other way.
For you, correct?
But no, and as I said to you when we talked about about certain issues, I said, Representative Nemes, you have forgotten more about AOC than I will ever know.
Well, I don't know if that's
we
true.
appreciate your holding us accountable and letting us know what's on your mind. We really do.
Thank you, Mr. Chief Justice. You got a great staff, and it's always an honor to have you at the table. Thank you, sir. Thank you, Mr. Chairman.
Senator Schickel.
Thank you, Mr. Chairman. Welcome, Chief. It's good to see you. I have 2 questions. First of all, I want to inquire about administrative release. As you know, quite a few years ago now, there was an attempt to codify administrative release into law in the Kentucky General Assembly. I was very much opposed to that. Thank goodness we didn't do that. But I understand that order is still in effect that has to do with administrative release, and I understand there's been some conversation about it. I'm wondering what the status is currently of administrative release.
We have administrative release. It is an order that we re-entered within the last 2 weeks. It does not include any violent crimes or felonies or misdemeanors that are violent. It's a laundry list of, I want to say, 5-6 pages of offenses that are not eligible. But it also it recognizes that there are certain nonviolent offenses, violations, Class B and A misdemeanors, Class D felonies that are nonviolent, and if we do look at the administrative or the PSA, the pretrial risk assessment. Those people are a good risk for coming back and showing up for court, and they don't pose a danger to the community. So before we reissued that order, we sent a draft of the order to all our judges statewide, district and circuit, and got their input, and we listened to their input, and we modified the order. So yes, we have the order. Katie Shepard, where's Katie? When did we enter that order? Okay, so I'll correct what I said. We haven't quite entered the order, but we are going to.
Thank you. There's a lot of discussion about that. Follow up, Mr. Chair? Thank you. The next is more of a philosophical question. It's not a direct question. It has to do with the Court of Justice, and in my mind, the Court of Justice becoming a social service agency. As you know, in the executive branch traditionally is where we have the social service agencies. But over the years, in my time in the legislature, we've developed a lot of what I call boutique courts, and I think that it's been done with good intentions. And but I'm just wondering if you have a view, and if you have any thoughts on the possibility is that we may be going too far in that area and diluting what the primary function of the Court of Justice is, and that is to decide just that, to administer justice.
I probably will defer that to the next presentation and my colleague, Deputy Chief Justice Lambert, and that. But part of it is what we're trying to do. People who have mental health disorders, substance abuse disorders, law enforcement has a lot of discretion as to the route they take with someone. Do you take them to treatment or do you take them to jail? And so it's not just social services, but it also impacts the capacity of our jails and our prisons to house these people. I know the General Assembly is concerned about the increasing cost of incarceration. And again, it's your all's prerogative to define crime, and we'll apply those laws. But, there's a trade-off. And so that's what we're trying to do. We're trying to reach the trade-off about people who truly have substance abuse disorders and or mental health problems that will not benefit by incarceration, but could benefit by community services such as they are.
Thank you, Judge. Mr. Chairman, can I have one more? Thank you, Mr. Chairman. Getting back to administrative release, is that the decision for those non-lawyers here on this committee? Is that decision of the entire court, or is that the decision of the Chief Justice to issue that order?
It's the decision of the entire court.
Thank you.
Whether or not I could do it by myself or not, I'm going to let the entire court do it. So it is the decision of the entire court.
Thank you very much.
Chief, on administrative release, what is the appearance rate or the FTA rate on folks released by administrative release order?
I'm going to have to defer
Sure.
that.
We don't have that information right now, but we'll get it for you.
If you could share that with us, so I can share that with the committee. In my anecdotal experience, the appearance rate is pretty good and the FTA rate is pretty low, but I'd be curious, and I think the committee members would like to know just how successful or not
Absolutely.
AR is. All right, any other questions? Members? Seeing none. Chief, thank you.
Thank you.
I appreciate
I
it.
think we'll turn it over to
Yes, sir.
Deputy
Ms. Rhodes,
Chief
Ms.
Lambert,
Comstock, thank
I
you.
believe.
Deputy Chief Justice Deborah Lambert, glad to have you up here with us to talk about something pretty important. And Shauna Mitchell, who is your hero.
Yes, she is my hero and my technology person. I do not operate technology very well and speak at the same time. So,
Well, you both have the floor.
thank you. Good morning, Chairman Westerfield and Elliott, and ladies and gentlemen of this honorable committee. I am so glad to be here today as chairman of the Judicial Mental Health Commission to speak with you about the exciting work that's going on with our commission. To my left is my hero, if you will, the project director, which is an inadequate title for Shauna Mitchell, of our Kentucky Judicial Commission on Mental Health. And we know that each of you here on this committee are as concerned as we are about the mental health of our fellow Kentuckians and those who are experiencing substance use disorder, mental illness, or intellectual and developmental disabilities. So we're very excited to be here to share with you today the really and truly groundbreaking work of the Commission, and thank you for your time and attention here today. We have prepared a short, or she has prepared, my hero has prepared, a few handouts for you and a PowerPoint. The state courts, of course, have increasingly become the default system for addressing the needs of and behavioral health issues of people who are in crisis, and a continued failure to address those systems just invites a continuing public health problem. And, of course, criminalizing behavioral health disorders certainly has a devastating effect on every individual who comes before us, their family, and society. And without access to services, the answer to the mental health crisis certainly falls on law enforcement and the justice system. So perhaps by default, we do, in fact, become a bit of a social service provider in that sense. This has broad reaching and lasting implication. As a general statistic, 4% of the general population has a serious mental illness, but 17% of our inmates nationally experience serious mental illness. And of that 17%, 72% also have a substance use disorder. And certainly incarceration negatively affects mental health outcomes, housing stability, employment, and their ability to integrate back into the community. So a well-planned state response can certainly prevent justice system involvement, recidivism, and negative outcomes for those individuals with behavioral issues. These significant concerns, as well as recommendations from our national and state partners, led to the establishment of the Kentucky Judicial Mental Health Commission in August of 2022. And our commission is charged with exploring and recommending and implementing transformational changes to improve system-wide responses for justice-involved individuals who are experiencing mental health, substance use, or intellectual and developmental disabilities. And there are currently 76 appointed members on the Kentucky Judicial Commission on Mental Health, and these members cast a wide net across the state, including judges, law enforcement, prosecutors, jailers, hospital representatives, private and nonprofit organizations, service providers, and faith-based organizations. And we have representation across the three branches of government and it includes agency representatives and legislative members, Senator Julie Rocky Adams, Representative David Meade, Representative Kimberly Moser, and Senator Whitney Westerfield are all on the committees or on the commission. And with us here today is my co-chair, Judge Larry Thompson. I couldn't remember which Judge Thompson I was talking about there for a minute. Sorry about that, Judge Thompson. At its core, we truly are a collaborative effort, and we seek to break through the silos and work more efficiently and effectively together. And during our very first meeting was just in September of 2022, we established committees consisting of multidisciplinary stakeholders to solve these problems. Really, this was the first time that many of these issues had been looked at with everybody at the table. These problems that we were looking at included, first, to just identify and linkage to services, enhanced court responses and diversion opportunities, and to minimize barriers that prevent individuals from receiving services, including stigma, transportation, and housing. Each committee met and elected a chair, a vice chair, and established work groups. The structure of the commission is we have three major committees: the Criminal Justice Committee, the Civil and Family Justice Committee, and the Treatment Access Committee. The Criminal Justice Committee established work groups focusing on juvenile justice, competency restoration, and pre-arrest diversion. The Civil and Family Justice Committee established work groups focused on dependency, neglect, and abuse, guardianship, and commitment, and domestic violence. And the Treatment and Access Committee established work groups focused on court responses to mental health, strengthening community response, and intellectual and developmental disabilities. Each work group began by openly discussing barriers and gaps, identifying potential solutions, and developing work plans for their next steps. You have this handout. It's difficult to read on the screen, but you can see more clearly how the commission is structured with established committees and each work group that falls under it. They meet fairly often by Zoom, and you can see the structure there of the work groups. The commission has certainly had a very busy first year. In February of 2023, the commission hosted a sequential intercept model mapping event. I have to speak very slowly when I say that. But the purpose of the SIM event, as the acronym is used, was to map out the points of contact that an individual might encounter while working through the system. Breaks everything down into steps. And by mapping those resources, you can identify gaps in a community. That's the important part. And it allows each community to identify the strengths and weaknesses in the system. And it helps us to know where each community needs to target the efforts. So it's sort of an odd name, I personally think, for it, but it does work very effectively. But SIM is used as an applied strategic planning tool to improve how agencies and services work together to reduce involvement in the judicial system. And these collaborations can include training, creating aligned policies and procedures, and working together to reduce barriers for individuals seeking care. Mapping identifies the intercepts or points along the way, if you will, at which individuals can be diverted or deflected from the criminal justice system. So as a result of that workshop, the National Center for State Courts developed a detailed findings report and gave 5 recommendations for Kentucky. Number 1 was the courts should be seen as conveners or leaders, and we should provide continued or access to continued education and training for professionals charged with providing community supervision, care, and support. We should make data-driven decisions and enhance data collection processes. We should provide a full range of high-quality services that address age and gender, cultural, and other needs presented across a behavioral health continuum of care. And we should involve peers and individuals with lived experiences and families. And we must listen to the voices of families and individuals with lived experiences. And in your materials, you'll find a one-page summary of this report, and the Commission is working very hard to incorporate those recommendations in our ongoing work. Our Mental Health Summit. We're so proud of our Mental Health Summit. We met on May 31st through June the 2nd in Louisville, hosting a summit of more than 1,000 individuals. All 120 counties were represented. It was an amazing event. There were over 100 speakers, 64 sessions, and 36 exhibitors. The summit is believed to have been the largest gathering of mental health involved professionals ever held in Kentucky. Each county went home with a plan for action. And I am hearing back from other counties about how they are continuing to have small town halls and meetings about what they're doing and what they're planning to do in their own communities. The agenda featured both national and state experts. The topics focused on the 11 recommendations from the National Judicial Task Force to examine state courts' responses to mental illness. They included leading change that promotes judicial leadership and convening efforts, deflection and diversion to treatment, competency to stand trial, promoting well-being for ourselves, our judges, and other professionals at risk for vicarious trauma, and civil commitment. The feedback has just been overwhelmingly positive. Attendees were asked to complete evaluations, and we have 2 comments from those to share with you today. One attendee said, "I was able to make connections with people who work in my county that I otherwise would not have been able to make. These connections are sure to foster professional relationships that will promote growth and strength for the justice-involved individuals that we serve." Another wrote, "I have learned to be less judgmental of the ones suffering with mental health issues, that there are many factors out there that are out of the person's control. I have gained compassion." Much of the Commission's work is being conducted within work groups. There are over 400 individuals serving across 9 work groups, and in the interest of time, I'll just highlight a few of the work groups and their efforts. The Dependency, Neglect, and Abuse Work Group is led by Judge Marcus Vanover, Family Court Judge for Pulaski, Lincoln, and Rockcastle. They are mapping and working to summarize understandable graphics, brochures, and guides that promote best practices and partnership. And the DNA Work Group is also implementing Upstream, a court and community approach that maps out resources, gaps, and collaborations to try to develop a clear picture of how families and children enter and move through the system of child welfare. And Upstream can simply be illustrated simply by the visual that we can exhaust ourselves by rescuing drowning people from the river, but we need to pause for a minute and find out why they fell into the river to start with and prevent that in the future. So I like that illustration about that work. It promotes preventative strategies and helps our communities and courts have better tools to keep families together safely. We also have the Competency Work Group led by the director of the Kentucky Correctional Psychiatric Center, Colleen Slusher, and they've completed an analysis of the competency evaluation and restoration process across the state. They're exploring screening and more flexible court orders that intentionally target individuals who truly need to be committed to the psychiatric facility for a full evaluation. The Intellectual and Developmental Disabilities Work Group is led by Crystal Adams, who's the Assistant Director of the Division of Developmental and Intellectual Disabilities within the Cabinet for Health and Family Services. and they're exploring law enforcement notification and training and creating a toolkit that will help courts better serve justice-involved individuals experiencing autism. After our successful summit, though, as successful as it was, we felt we were missing the consumer piece. And after that, we decided to have town hall meetings. And we piggybacked with the Kentucky Bar Association to save money. And we have held 9 town hall meetings throughout the state associated with the Kentucky law updates. These town halls have been used to gather input from individuals with lived experience and who have actually navigated the justice and behavioral health systems. We wanted to hear directly from our citizens. It has been a very powerful and very humbling experience to hear their stories. They're very personal stories. So far, over 600 people, have attended. We've heard from a mother whose son was released from an involuntary commitment, and now she has no idea where he is. We've heard from a woman who vividly remembers the trauma associated from being removed from her home as a child when her mother was arrested, and how that trauma has led to her own mental illness and her own use of substances. We've heard from an aunt whose nephew died by suicide just days after seeking help. And these stories we are hearing are impactful to our system and have highlighted its gaps. The information we're learning from the town halls will be used to inform future training and shared with the corresponding work groups to explore solutions. We go in there and we say, we aren't here to tell you what the answer is. We want to know what problems you're experiencing. And it has been a very powerful time of learning from our people. We would like to thank all the courageous individuals who have attended and shared their personal stories across the state. I would like to invite you to attend one of our remaining events. We will be in Louisville next on November 8th, Pikeville on November 15th, and Bowling Green is our last site on November 29th. All town halls are from 6 to 8 p.m. local time, and there's a more detailed flyer available in your materials. After each work group after each work group identified barriers, they were asked to explore potential legislative recommendations. The Commission reviewed those and realized that many of the issues that were identified didn't really need a legislative response, but were more of a policy or process clarification. There were a couple of barriers, however, that they believed could not be addressed outside of legislative changes, so the Commission will be moving forward to present some legislative recommendations this session. The Commission is still working to finalize the specifics. We have heard concerns from the Commission's competency work group regarding the months-long wait list for defendants to be seen at KCPC, the Kentucky Correctional Psychiatric Center. KCPC is currently the only forensic psychiatric facility in Kentucky that performs inpatient competency evaluation for felony offenders. Beds are limited and the wait list is long and complicated. We have learned that about 67% of the offenders who are sent to KCPC are ultimately found to be competent to stand trial. This ties up the beds that are limited anyway and slows the system down. So we're exploring changes to our system that would be similar to the model followed by Tennessee. And in Tennessee, what's done is a licensed clinical professional goes in and initially evaluates the defendant, and only then, if further evaluation or treatment is thought to be needed, a defendant is then referred to that psychiatric facility for further competency evaluation or restoration. This pre-screening process should allow defendants to be evaluated more quickly while reducing the wait list for those who are actually in need of KCPC services. The Commission's Guardianship and Commitment Work Group has heard about patients who are suffering while waiting for someone to be identified to make a medical decision for them. The current statute only allows for a guardian, an individual with power of attorney, a spouse, an adult child, a parent, or nearest living relative to act as a decision maker. The Commission will recommend that a friend be allowed to be designated as a medical decision maker. By mirroring an Indiana statute that allows an adult friend, i.e. someone who has regular contact and is familiar with the individual's activities, health, and religious and moral beliefs, to make those healthcare decisions, the Commission believes that that will be an improvement in our system here in Kentucky. The Commission certainly is enthusiastic about sharing the few legislative recommendations this session, and certainly would be hopeful for your support. The Commission will move forward in exploring some critical systemic barriers, and with the support of our partners, we will continue our statewide efforts. We'll be offering regional trainings, working on how to better respond to individuals with mental health and substance use and or intellectual developmental disabilities and their unique communities. I know that we were able to do these town halls and sort of piggyback on the Kentucky Bar Association sites. Those were only in 9 cities. We hope to do some follow-up daytime meetings in some other cities throughout the state, but those will come in the upcoming year. We are excited to announce that we will be establishing a new reentry work group that will follow the December Commission meeting. This work group will focus on eliminating barriers for incarcerated individuals who are re-entering society. We celebrated our 1-year anniversary in August. It has been a very busy year. It's been a year filled with learning and exploring our current system. I have learned so much about our court system. I've been to KCPC and Western State Hospital and Kenton County Jail, and it's been a long time since I've been to jail as an attorney, but it's important that we get out there and see what our services are, and we have done that as a commission. We are working to identify resources and opportunities to improve how we respond to individuals with specialized needs. Addressing the behavioral health needs in our state is certainly an important but weighty undertaking that's going to require sustained effort and time. We certainly cannot do this alone, and we recognize the legislature as a very important partner, certainly. And we sincerely appreciate all your work in this arena as well. And if you are interested in learning more, being part of this commission in a more active way, please reach out to our commission staff or visit the web page. And thank you so very much for allowing us to present today, and we'll be happy to field any questions you may have.
Thank you, Justice Lambert. I greatly appreciate that. And I appreciate the work of you and your office and Shauna and everybody on the commission, because you've been meeting a ton and taking a ton of input from across the state, and I greatly appreciate that.
Thank you.
I was there for the summit, the meeting back in May. It was very well attended, and a ton of really good information was shared and learned from a lot of folks, myself included. I'm glad you mentioned KCPC, because it was on my checklist to ask. And even as we've been sitting here, I've gotten a text from a judge who's reminding me that how big the problem it is in their own circuit.
Absolutely.
So I'm glad that you all are exploring what other options on the front end to try to filter out some. If 60% of them end up being found competent, if there's a way to filter some of those to keep them from going and tying up a bed, that's good. have you all, or has the Department of Corrections, which I think facilitates KCPC, if I'm not mistaken, but has anyone talked about using private providers to help pick up some of the slack? Because the waiting list, as you mentioned, Justice, it's jamming up every criminal docket in Kentucky.
Right. I think we're limited by statute to
Really? Okay.
using
The
case.
Cabinet for Health and Family Services is the
So
the
CHFS
entity.
runs
Yes.
KCPC.
Yes.
Okay. All right.
And currently, the statute says that they are the only psychiatric facility that can do that. They are contracting. They do contract out some state competency evaluations, but they're, with Eastern State Hospital.
That seems to be something we ought to fix.
Well, we're absolutely looking at that as at the commission.
Surely there's somebody out of 138 that could sponsor such a bill to open up that eligibility, so that just then, either that or give them more people. There's a behavioral health clinician shortage, just like there is in just
Yes.
about every other healthcare space.
Right. And just finding those other people, even if there's
Sure.
a budget for it, is difficult, I understand.
I appreciate you all are giving it attention. You've got a lot of defendants, and for every defendant, there's a victim out there, and they're all waiting for these evaluations to be done in a more timely fashion than it's happening right now. So I appreciate that.
And our judges are also working with KCPC. Many of them are doing remote evaluations by almost like a telehealth
Sure.
kind of evaluation. So
And for some, I think that would be really helpful. I don't know that it would be great in every single case.
not in every case, certainly.
Thank you. Representative Bratcher,
I have a series of questions, Mr. Chairman, and
we got a little bit of time. Just keep it concise, sir.
okay, Justice Lambert, thank you for coming. And it looks like wonderful work, and I'm sure that this is an area that needs to be addressed. I'm just a little bit confused. What makes a Supreme Court order? Who decides a Supreme Court order?
Well, right now it takes, I guess, all of us to consider it. All 7 of us consider it, and I suppose a majority of 4 would make that order.
And who is funding this commission?
Currently, I think it's all being funded within our budget. Is that right, Katie? Within our own budget, yeah. And we're kind of operating on a shoestring. We're not paying for event space for the town halls and that kind of thing.
Do you think town halls and the activities that you're doing with this commission is out of the role that a judge, especially Supreme Court, should play?
We were charged with this. This is a national movement. We are following the national guidelines, if you can speak to that as well, Shauna, but it's a national charge for courts to become more involved. It has fallen upon the court system, the prison system, and the mental health system to do this regardless. I understand the legislative concern about our roles, but the job has fallen upon us regardless. And so what we're trying to do is put some preventative things in place to reduce the judicial involvement. And Ms. Mitchell, do you have a...
I think you said it well, but it is a national, it was promoted nationally by the State Justice Institute and the National Center for State Courts, because it does become a courts problem. Unfortunately, a lot of times law enforcement, they end up coming into the jail system, being charged, and they have to be processed criminally, and therefore it might not be the appropriate setting for individuals to go into jails or to go into courts. We're not equipped to handle those. And so looking at the courts as leaders and conveners, when a court calls a meeting, when a judge calls a meeting, oftentimes they tend to show up. And so if the courts lead this, then they can pull in those community partners that it really is their job to provide those wraparound services to individuals experiencing mental illness, substance use, and intellectual developmental disabilities. They can pull those people together and make those appropriate referrals, and then it clears up their dockets, and those individuals are receiving better services.
It said on the very first slide, if you could go back to that.
Mm-hmm.
Okay, the second slide, I'm sorry. It says implement somewhere up there. To explore, recommend, and implement changes. So that means that you basically are making changes. What changes would that be?
Well, I'm not sure.
Here's my concern. I'll just
Sure.
get
What?
to the point.
Sure.
It seems like this is an executive or a legislative function. And when we do commissions and we start implementing things, you guys are there to oversight us, right? And the executive branch, that's the role you play. Who's oversighting you?
Well, I suppose that we are a joint commission, if you will. We're part of the executive branch, the judicial branch, and the legislative branch. We are all working together. It's an attempt to break down the silos between us.
What would be an example of implementing a change in this commission?
Well, let's see. I'm trying to think of something that we may have done already in terms of a duplication of services or something. Can you think of something, Shauna?
So we look at things that we can impact with policy or practice, and we will talk to those agencies about changing the practice. With mental health courts, in Kentucky, we don't have a lot of mental health courts, although we recognize that there's a large need for it. So one of the things the commission is doing is promoting the establishment of mental health courts. We've created like a collaboration and communication guide that we've shared with communities to help people understand who the point of contact is. We're creating resource guides, toolkits for judges, bench cards that will help promote those efforts and bring in together teams within communities to come together and map out their system. We do plan on providing
the former Chief Justice, every time he would come, I would kind of needle him that it takes so long to get a decision. And why does it take so long? I think like the redistricting law has been with you in the system for knock something off, has been in the system for 2 years or maybe quite a while. And it seems like some of the laws that you guys address constitutionally, it takes a long time for you to come up with a decision. And I used to needle him, what is taking so long? And you say you're very busy with this. Could this be one of the reasons it's taking so long to make a decision on some of the, I could go on and on about the Court of Appeals sitting on a case for 3 years in my district. And it just seems the courts take forever to make decisions in some cases. And that's just frustrating to me and some of the people in my area.
Right.
And you don't have to address that. I'm wondering, why that's the case. So thank you, Mr. Chairman.
Thank you, Representative Moser.
Yes, thank you, Mr. Chair, and thank you so much for being here. I'm very proud of this commission and the work that you're doing, and I was proud to be part of the meetings, the initial meetings at the Chief Justice Association meetings in Austin, Texas, with Shauna and the AOC and all of our friends in the different branches of the government. And so we were able to really see what was happening across the nation in terms of making sure that we are taking care of individuals who are entering the criminal justice system for one reason or another. And as we see on the second slide, more often than not, it's because of mental health issues and substance use disorders. And we know that housing individuals with medical issues and needs, such as substance use disorders and mental health issues, is an inappropriate use of taxpayer dollars, honestly. And several years ago, the numbers of cost to taxpayers for housing individuals or just our jail budget, I guess, was about $600 million a year. Do you have an updated number, or can we get that?
I don't personally have it. We can get it, though.
We will look into that.
Yeah.
Cost.
So, I mean, and my point in bringing this up is that it's more appropriate for, and the court has been thrown into this system, this is not historically what you've had to deal with, but
It is not.
But it's our current reality. And we need to redirect individuals to appropriate levels of care. And that's what you're doing. And so the implementation of these best practices is really what we're doing in addressing all of the needs to appropriately rehabilitate or correct behavior. That's what corrections to me means. And how do we best do that? We look at our current reality, and it's folks who are being housed in jail because we don't have any other resources currently, and redirecting them to the appropriate level of care. And so I am, like I said earlier, very proud of the structure that you all have put in place to really look at how we intercede. This is the sequential intercept model, how we intercede on behalf of individuals who can't advocate for themselves. And that's really what's happening. And it's a very systematic approach. There are recommendations that come out of the commission to the legislature that look at lifting barriers that we see either statutorily or, how do we best streamline services? How do we really affect positive change for individuals? So I see this as a very positive, relevant way to address the system and keep people out of this perpetual cycle of relapse and recidivism, which is what we're doing now. So I applaud all of your efforts. I'm proud to be one small voice in this system. So thanks for all that you're doing.
Thank you. And one way that we seek to implement a lot of the changes is by proper training and training judges on trauma-informed care, training judges on mental health issues, training judges on autism, training police officers at our summit, training jail employees at our summit. All this training together helps us all to understand our different roles within the system to serve our people.
Senator Wheeler.
Thank you, Mr. Chairman. I guess a couple questions. One, as far as evaluating people for mental health disorders, you said that there's some budgetary constraints, and I mean, a lot of these people I know generally will have a medical card or something like that. Will that pay or enable them to use the private sector to get some of these evaluations?
Are you talking about the 202A evaluations?
Or if we could employ folks in the private sector and utilize these resources to maybe expand access to get these evaluations done more quickly.
Okay, competency evaluations.
Yeah.
I think that's all covered within the state budget and the KCPC's budget. So it's not a question of their own insurance coverage or Medicaid.
And I guess the second question, is kind of a comment and a question. I think we do have to remember behind, every defendant not behind every defendant, but in many cases behind every defendant, there is an actual victim out here that, has suffered. And, even if you have a mental disorder, that shouldn't be a get out of jail free card.
Correct.
We all cried at the end of Old Yeller, but we couldn't let him go around and keep biting people. You have to occasionally, approach these things to protect greater society rather than, people that are out of control. And I think that is something we have to keep in mind as we go down this route.
Yes.
Thank you, Senator. Representative Burke.
Thank you, Mr. Chairman. Thank you, Deputy Chief Justice Lambert, for your work and your presentation today. And thank you, Ms. Mitchell. I've had a lot more overlap with you, as it's been my privilege to serve in two of the work groups that are addressing some of these issues. I really want to bring to the committee's attention the fact that this is not simply about criminal justice. That's only 1 out of 3 of the areas of law that are being impacted by this work group. And we sit in these committee meetings week after week and month after month talking about the various crises in our institutions, whether it's in the jails, our foster care system, or in mental health hospitals. Vulnerable people are struggling across our communities in institutions that are funded by this body. So it's critically important that we look at what we're doing, that we take stock of how we are treating our most vulnerable citizens. And that's why I think that this commission is so important and that this work is so needed and so timely. When I think about children in foster care sleeping in offices, and I know that the reason that they're there is because we haven't taken care of mom's mental health issue, that breaks my heart because we are just perpetuating that cycle. So we can do better, and this commission is the way that we do better. My question for you: do you believe that better preparation of judges and court staff will alleviate some of the critical issues that are facing the Commonwealth? And do you believe that this work can achieve good outcomes within the next 5 to 10 years? Thank you.
It has to help. I think the more prepared and the better trained our judges and staff are to recognize a family crisis or a trauma, or the more informed a judge or staff person is about what services are available in the community. That's why this SIM mapping process is so important, because we're going to know what services are available. I'm not a big city person. I'm a rural person, and I kind of shiver a little bit when someone says, oh, there's no services to speak of in rural communities. Oh, yes, there are. And there are services there. You just have to know what they are and how to access them. And so we can have our judges and our staff a little better trained sometimes, and get those people directed to the proper services. So yes, we think we do a pretty good job now, but it's a constant moving thing with the change of personnel. So we have to feel that pressure all along to keep that training going. Yes, thank you.
And may I ask one follow-up?
I need to move along because we need to start the next panel, but I do want to let Representative Nemes ask very quickly.
Thank you, Mr. Chairman. Thank you. I want to say thank you for being here, Deputy Chief Justice Lambert. We've known each other for a long time, decades, and you're a justice that writes clearly. I read all the opinions. You take on hard issues. You've done that for a long time. Wanted to mention, my friend Representative Bratcher was here, and I think you had a lot of wisdom in there, but I also wanted to mention that this work has an eye toward making sure that we have fewer future victims. That's what all our work does in the court system. Holds people accountable, yes, that's very, very important. Don't want to minimize that, but it also wants to make sure that we have fewer future victims. My point that I want to ask you, though, because it was work that you did as a family court judge a long time ago, we have a chronic problem across the Commonwealth, and especially in Louisville, of kids not going to school. 38% truancy. You were one of the trailblazers in drug court and a lot of things as you're doing here with mental health. But you were also a trailblazer in truancy court. But I've seen that kind of fall off, and I want to suggest to you and to the Chief Justice that let's pick that back up. We have 38% of our kids that are missing, I think, more than 10% of school in Louisville, and those are the kids that are the most at risk. So as we're doing this good work, let's also think about how we can get the court system involved in making sure our kids go to school, and if they don't, let's hold those parents accountable. Thank you, Madam Chief Justice.
Thank you.
Deputy Chief Justice.
Thank you.
Thank you, ladies. I appreciate it. All right, I want to welcome up Director Comstock, Angie Darcy, and Jason Dufek to talk about Senate Bill 90. As they're making their way up, I think this is a perfect combination of presentations here that fit hand in hand. Part of the importance of the court looking at behavioral health and mental health issues generally around the state is because, and I think, Senator Sugar, this is partially in response to your question. I had an answer to your question. I think there's a line beyond which the court can't act, because it is something that the executive branch or the legislative branch needs to deal with, particularly the executive branch. But I think there are some instances where efficiency and for effectively adjudicating the cases in front of them, I think there are some things the court ought to do to explore, particularly in the behavioral health space, because the intersection of the people involved with the criminal justice system, because they've broken the law, there's a bunch of people that have those needs. And different states are experimenting in different ways with how best to respond. There's some things the courts can do. There's some things the executive branch agencies need to do more of. Senate Bill 90 is a nice partnership where we've got a couple of different branches of government working together. And I'm glad to hear the update on how things are going in, I think the chief, you said there were 7 of the 11 counties right now that are live, and the others are going to go live by the end of the year. That's good. I won't steal any more of the program. You have the floor for our last 27 and a half minutes.
Okay, we'll try to make this speedy. But good afternoon, and thank you to Senator Westerfield and the committee members for allowing us an opportunity to present today on the exciting pilot program that really was created by Senate Bill 90. Again, I'm Katie Comstock. I'm the new director of AOC. With me today are Angie Darcy, our executive officer of pretrial services, and Jason Dufek, manager of pretrial services. The Mental Health Commission presentation is really an excellent segue, as Senator Westerfield noted, into this discussion on Senate Bill 90, as we look at ways to address behavioral health and substance use issues in the Commonwealth. Through Senate Bill 90, pathways have been created to face behavioral health and substance use issues experienced by justice-involved individuals for the benefit of those individuals, as well as the courts and the Commonwealth. Targeting low-level defendants charged with low-level offenses, Senate Bill 90 sets the stage to divert defendants away from jail and into treatment for substance use or mental health disorders. This is a new approach to alleviating the effects of the opioid crisis in the Commonwealth. Senate Bill 90 identifies and assists low-level offenders with treatment and services before they become high-level and high-needs offenders. Through the allocation of monies from the opioid abatement funds, these services come at no cost to the participants. In conjunction with the Department of Behavioral Health Development and Intellectual Disabilities, as well as the Kentucky Adult Education, AOC has spearheaded implementation efforts for Senate Bill 90 into the selected pilot counties. In this presentation, you will hear how implementation efforts began, how they're continuing, the results of the data we've gathered, and Senate Bill 90's challenges and successes. So at this point, I'm going to turn it over to the people really who have put hours and hours into Senate Bill 90. So turn it to Angie and Jason.
Thank you, Director Comstock, and thank you for having us here today to present. I'm excited to present on this. I also want to note that we have a couple partners in the audience today from BHDID. I think we have Dr. Allen. Dr. Allen, are you back there? There she is, right up front. And I believe that we also have Dr. Gregory. Dr. Gregory here? Yep, he's back there as well. So we are definitely not doing this alone. So I want to mention that they are here, but since this is the Judiciary today, we are presenting on it. Senate Bill 90 is, as Director Comstock stated, it's an alternative to incarceration, and it seeks to divert low-level defendants, low-level on our pretrial eligibility criteria for failure to appear and for new criminal activity, divert them from the criminal justice system if they have a behavioral health disorder. Behavioral health disorder is a mental health treatment disorder or a substance use disorder. The bill mandates that they are, if they are incarcerated, that they are assessed within 72 hours by a mental health specialist, and the goal is to divert them completely. Our eligibility criteria is set out by statute, and it is well defined that they must be a Kentucky resident. They have to be 18 years of age. They have to be charged with a qualifying offense, and they can't also be, they can't have a previous conviction for a Class A, B, or C felony, or a Class D felony or misdemeanor that is not a qualifying offense. What is also interesting to note is that there is a list of non-qualifying offenses that are predetermined by the statute as well. DUIs, for example, domestic violence. So if they have a previous conviction of a DUI or domestic violence charges, they also would not qualify for Senate Bill 90. They are assessed by our department, pretrial services, to see if they are low risk for failure to appear or low risk for new criminal activity. And we're the ones that do the eligibility determination as well. So we do the first steps and determine if they're even eligible for the program. If we determine on our face that they're eligible for the program, then we will have them assessed by a mental health provider. Currently, that is BHDID has contracted with a company called CareWise. I believe that is changing in the beginning of the new year, most likely. And that clinical assessment will determine if they qualify for the program as a whole once we make that determination. It's also important to note that the prosecutors and defense attorneys can do overrides on these. So anybody that may not qualify, they can override that criteria and put the defendant into the program. They first have to be they have to have that mental health clinical assessment, though, to determine if there's an issue there. So here is the program overview. If they are determined to be eligible for Senate Bill 90, the prosecutor can enter into an agreement with the defendant to participate. The program provides an array of services, so it just doesn't do treatment. It also provides case management through the behavioral health provider, and that case manager can take that defendant. They can see if they need housing, if they need, if there's other things, if they need social services such as food stamps or, the other Medicaid eligibility as well. So it is a full package. It's funded under the Opioid Abatement Trust Fund. And what'll be interesting to note, and what we've kind of found is very eye-opening, is so far with, we've only had one defendant that hasn't been eligible for Medicaid. So the defendant's insurance pays for all the treatment, the case management aspects. So as of right now, we've only had one defendant that has had a private pay. This is what we started out with. So this is interesting. This is what we call our lollipop map. And our lollipop map is neat. It's very colorful. And when we first started designing the program and talking with our partners, this is kind of what we came up with and what we developed. It's a very neat package from eligibility to the end of treatment with the final report there. And we'll talk about a little bit more of that later. I believe that everybody should have a package that can talk about what we call our lollipop map. So right now, here are the current Senate Bill 90 sites. We are live in 7 counties. We are getting ready to, we've hired officially, or we're working on finally hiring our case navigator positions. And so we will be live in Davies, Greenup, and Kenton, hopefully by the end of the year. That's our objective. So we are interviewing for those positions right now, and we hope to get those filled. I'll talk about a little bit about the case navigator position and how it's become critical. It wasn't something that AOC came up with. It was actually something that our community members came up with when we did some of those community forums. So we're doing a lot of data collection with Senate Bill 90, so we have a lot of numbers, and we'll have some of those numbers for you, and we're always glad to provide anybody with additional numbers if they would like to see them. But it requires the treatment providers to collect data and report that to us. We collect it via a 14-day report, a 42-day report, a quarterly report, and a final report. Examples of the data that we collect is the number of participants eligible, the number of clinical assessments that we do, the number of participants that are actually in the program, the number of participants that are discharged for compliance reasons and for non-compliance reasons, and the number of victims that agreed or disagreed with the program, et cetera. So implementation, that has been something that we have been working on, and we're constantly kind of going back to the drawing board on a regular basis. We have biweekly calls with our partners, BHDID, and also adult education. We have biweekly calls with them where we kind of talk about the barriers, what we need to go back to the drawing table on, and such. But so first we identified the key stakeholders, which was the Implementation Council. We also did some work groups. We had treatment work groups. We have a education and training work group, and then we had stakeholder meetings. We also did a lot of mapping in the beginning as well. We did mapping internally with AOC, and then we also did a mapping with BHCID and adult education, where our touch points would be with these defendants. We have a lot of data points that we mapped as well, and we did a lot of action planning. So let's talk about the community forums. So we went to every single community where we were going to implement Senate Bill 90, and we had forums, and we just talked about what Senate Bill 90 was going to look like. We got a lot of feedback from our community members about what they wanted to see, what they expected. We had behavioral health providers there. We had judges there. We had police officers there. We had prosecutors, defense attorneys. It was a pretty wide array of community members there that were really interested in Senate Bill 90. And the forums also provided an opportunity for concerns, and they were followed by one-on-one meetings with the individual stakeholders in the pilot counties. One of the things that we heard a lot when we did those community forums is who is going to be, are we going to have somebody in the community that oversees kind of the court process and how it's working? And we didn't think about that originally, and as we went to every community forum, that's something that we heard over and over and over again. So this is our new map. So you saw the lollipop map and how nice and neat and how well it fit together. And once we started getting into the actual process and started implementing it, well, things got a lot more messy. And that's the way it works. So there's a lot of moving pieces there, and you'll see us talk a lot about the case navigator, and this is kind of how the case navigator's role is. It's to navigate them through the process. Somebody has to make that initial connection with the prosecutor and the defense attorney, and also with the clinical assessment piece, and that's what that case navigator does. It just helps the defendant through that criminal justice process. Process and practice changes. So we did form creations. We have a lot of forms on Senate Bill 90. We'll also be happy to share those forms with you if you're interested in them. Most of them surround the data collection points that we're required to collect by statute. And so that's the 14-day report, the 42-day report, the quarterly report, and the final reports for the treatment providers and prosecutors. And then we had a lot of existing staff training for our pretrial specialists, because they are the ones that are determining eligibility with our risk assessment specialists and our pretrial service specialists. With that, with our pretrial risk assessment, they have to flag who would be eligible, so they also have to determine if they'll even be eligible by those legislative mandates in the beginning. So we are the first ones that determine if they're even going to be eligible to have that mental health assessment. And then our case navigators, we've established a lot of local procedures. We're actually developing policies and procedures and practices as we go, some best practices for them to follow. We have our Implementation Council. This is just who is on the membership of the Implementation Council. This is also set out in statute. So this is an example of who we have on that membership council. We do meet quarterly. Our next meeting is coming up on November 15th. We welcome anybody that would like to attend those. They are open to the public. And we hashed out a lot of the issues at the Implementation Council. So it's educational, and also we welcome anybody that has issues or wants to discuss some problems. That's what those Implementation Councils are there for. Senate Bill 90 in action. This is just a little bit of the data, but I'm actually going to now slide this over to Jason Dufek and let him take over, and I will follow up with some of the barriers and successes.
Thank you, Angie, and thank you, members, for allowing us here to talk a little bit about the data. As the slide shows, we're currently live in 7 counties. Those are Letcher, Madison, Clark, Pulaski, Hopkins, Christian, and Oldham. McCracken County is slated to go live on December 1st, and we are in the hiring process in the other 3 counties to get them up. Our goal being to, as close to the end of the year, begin, turn of the year as possible. We've had over 1,000 pretrial eligible defendants since January 1. And so even though that the 11 pilot counties have gone live with the program in a staggered schedule, what we've done is beginning January 1, we screened everybody just so we would kind of have some data to look at so that we could present on that and see what was going on. So even though there's nobody in McCracken County that's eligible to go into the program right now because they're not live, we still have data since January on the folks that have came through the door. We don't know whether they had a behavioral health or a substance use disorder because there was no clinical assessment done, but we know based off the pretrial eligibility, and that is their criminal history and their current charges, as to whether or not they would have moved forward to that step. We've had over 150 defendants that have voluntarily agreed to complete the clinical assessment, 140 agreements that have been signed. We have 13 folks who have already successfully completed the program. Unfortunately, 2 people who voluntarily withdrew from the program, 8 folks that have been dismissed, currently 23, which that every time I look at the numbers, 23 seems to be the agreements waiting to be signed. I don't know. It hovers around 23 for some reason. And 57 defendants that were denied entry into the program due to prosecutor denial. I know.
Do you know what the basis for those denials were? Because they're required to say what
they are, and we're working on compiling all that information now. I will definitely get that to you. And I don't know off the top of my head what the specific reasons were. Or nothing that is of note to point out at the moment. But we will get that. We have those forms.
And when we get the quarterly reports, we'll be happy to report back on that.
Moving on to the eligibility, and as I stated prior, we've been screening every person in those 11 counties at that initial level. And you can see of the low defendants there, we have 1,073 that would have been eligible for that assessment, 150 roughly that are unknown, and 2,027, almost 2,800 folks that are ineligible that were in that low category. Of the moderates, there's been 10,000 of those. High FTA, 2,600, and high NCA, 1,700. And I'll talk a little bit more about what makes those folks ineligible that were low. Because we've, again, with collecting the data in advance, we've been able to know that. So the question number 1, and these questions correspond, you all should have in your packets that screening form. The numbers here correspond to those questions on there and what is causing somebody to be ineligible. As you can see, the first question there, Kentucky resident, we've had over 60%, barely over 60% of the folks that are Kentucky residents. Those unknowns are a lot of times because we'll try to screen them as quickly as we can. Sometimes we don't know until after the fact what their residency status was. So that unknown number kind of hovers in there a little bit high. You can see the A, B, or C felony. A prior A, B, or C felony causes 13% of those folks to be ineligible. As you work down the list of violent offense, and a lot of this is just due to the nature, there's not a lot of violent offenses that are Class D felonies.
Jason, let me ask about, and you've heard me say this before in our conversations privately about Senate Bill 90, just between me and AOC. I would like to see both DUI and domestic violence carefully removed or artfully partially removed, because those are 2 categories of offenses where there's clearly a behavioral health issue at the root of it. Do you have any sense on DUI in particular, how many of these are first offense or?
I do not, but we can get that. We have that data, and I can get that back to you.
I'd be curious to know.
Yes, sir.
And then break out, and I don't think I've asked for this before, but I'd be curious to know about the breaking out of the various DV offenses or domestic violence charges or related to domestic violence or interpersonal violence. I'd be curious what those charges look like.
Yeah, we'll make sure. We'll do a deeper dive into that and get that information back to you. And as you can kind of see here, again, not knowing whether it was DUI first or if it was a second or subsequent offense there. But we do have, those numbers. 71% of the folks are eligible. The remaining, those are folks that were charged with DUI. If you jump a little bit lower, you can also see, and as you've alluded to, conversations that we've had, having a prior conviction on your record for DUI. And generally speaking, that's going to be within the last 10 years. The records are maintained for 10 years on DUIs because of the look-back period there. You can see those numbers. And so there's a significant number of folks that are, ineligible for the program, not because they're currently charged with a DUI, but because in the past 10 years, they had been convicted of a DUI, and that's on their record. Some of the other disqualifiers, the sexual offense, being charged with a sexual offense or attempt of a sexual offense, you see those numbers are very low, there. Same conviction for a violent offense, and again, these are folks that are low risk individuals, so you tend not to see those. So it's barely makes a blip on the chart there. The domestic violence or interpersonal violence, low number, but we'll get that to you, what those convictions were for. And then following down the other questions, the prior conviction for a sex offense or attempted sex offense, those are almost no statistics on those. We've got this chart here, and I know there's a lot of data on here, so I won't attempt to read every bit of it to you. It's there. If you have any questions, let us know. But this is...
And we only have about 6 minutes left.
Okay, so this is the interviews that received the eligibility assessment, and it just shows, a little bit greater detail, a little bit more granular there. I'll move on to the... so of those folks that have been assessed and that were eligible, you see we have 204 people that completed that. We did have, a decent
What's
amount
declined
of folks.
on this mean?
So a lot of times these are folks that are no longer in custody, and so
the defendant declined.
The defendant declined, yes,
Okay.
sir. Yes, sir. And then we have a few folks that were already in the program, and the prosecutors allowed them in on if they picked up a new charge while they were waiting. You can see here the number of those folks that are in the program, what it was that kind of put them in the program. You can see the 120 some folks with co-occurring, but which means both mental health and substance use disorders. And then we had 2 people, I think it was, that there was no indication of a mental health or substance use disorder. So you can see of the folks that are making their way to the screening, a lot of them there is an underlying issue that's able to be treated. And with that, I will turn it back over to Angie. As I said, I'll get you those numbers, Senator. I'll make sure that the committee has them.
So some of the implementation barriers, it's important to note that we do still have some hesitation from some of our stakeholders, be it prosecutors or defense attorneys. We have, over time, it seems to ease. But in the beginning, I think when we were originally implementing it, with the exception of Letcher County was very completely on board, and that was our first pilot county. But with every other county, in the very beginning, we do have some pretty big barriers to get through with the prosecution and defense. We are getting there, and once they see the program actually being implemented, then they tend to jump all in. So we are getting there with it. There's also a role clarification issue sometimes with partners and providers. One of the things that we saw initially, the behavioral health providers didn't originally think that they had to provide case management, and they weren't sure who was providing case management, but originally we were kind of running around, with their heads cut off, but now we've got a little bit more on boardness with the behavioral health providers as well. The eligibility criteria, as we discussed earlier, finding qualified mental health providers has been quite a barrier that we didn't really think about in the beginning, but it is definitely one of our biggest barriers that we have right now. And transportation in rural communities. So Medicaid does pay for you to get to your behavioral health provider, and will also help you find transportation. However, for anything else that isn't related to the mental health or the medical treatment, like going to adult education, for example, and doing that original assessment, it doesn't pay for that. So we are
Is the Implementation Council looking at using some of the appropriated funds to address that or to cover that gap?
And I think that that is something that behavioral health is actually working on, and maybe adult education is working on that as well. And Dr. Allen can...
I think we might have maybe early on in January have the other agencies involved come in and give an update from their side on
that sounds good.
Not just CHFS, but also workforce, vocational. I think that's important for us to hear from.
That sounds good.
I'm gonna stop you there because you're about to go into the successes, and I don't want to stop you there. But everybody's got that slide deck. Does anybody have any questions? Here with 3 minutes. Yeah, Senator Schickel. And
then not questions, Mr. Chairman, more general comments, if I may.
If it's just a comment, let me get Senator Turner, who does have a question first, and then I'll come to you, Senator.
Thank you.
Yes, sir. Senator Turner.
Thank you, Mr. Chairman. I thank you all for your presentation here today. A couple questions. Under the 57 defendants denied by the prosecutor, do they have carte blanche authority to say we're going to deny it, or I just need some understanding of what that means. You mentioned something about it. Letcher County's fine, but so give us a little.
I'll give you a short answer. They do, and that was a Medicaid reimbursement concern.
Oh.
We wrote the bill so that judges couldn't order it, even if the prosecutor objected. We couldn't write it that way because there was a concern Medicaid wouldn't reimburse it, because then it's court ordered. There were other states have different experience. I'll tell you that around the country, and I've talked to legislators, particularly out west, that don't have that problem. I don't know why Medicaid is different for them, but we wrote it so that the prosecution has to agree.
One other question, sir.
Yes, sir.
On the DUI, if someone has a charge, are they denied, or are they have to be convicted?
Even if they have a charge,
so
they're denied.
Okay, if that charge has been dismissed or they're found not guilty, are they then eligible?
Sure.
Okay. I'm just trying to clarify that from what he said. And one other, Mr. Chairman. Yes, is there some timeline that you as a group will find that it may be appropriate, since they extended that time from 5 years to 10 years, that there might be a time when somebody should be eligible, like, because as it's been mentioned, somebody's got a drinking problem, but they haven't shown it in years, and then they have some little setback of something else, they're going to be ineligible just because of something that happened 8 years ago. Do you all going to be able to bring something back to us to say there may be an appropriate time to change that?
Yes, sir.
Yeah, and I think with DUIs in particular, when it's a previous conviction, what we've seen is those are probably good candidates to enter at any point. So we would be okay, and I think our partners would also be okay with doing that. And I think that may be more of a judge question with respect to that answer.
Well, as a practitioner, I would say it would probably be better for a legislative position, because you're going to have too much variance in the state, and that wouldn't be what we're up here to do, is to try to keep it for the same for everybody.
I would wholeheartely agree.
Thank you,
with
Mr. Chairman.
Thank you, Senator. Senator Schickel, last words.
I'll defer. That my time's up. I'll defer.
Yes, sir. Thank you all. I appreciate it. I appreciate the hard work that you're doing to make the pilot a success. Hopefully we can expand beyond the 11 counties at some point, but I'm eager to see the continued growth into the 11 counties that we've authorized already, or that you all have authorized already. And I do want to have those agencies back to the other ones that you're working with, both within CHFS and elsewhere, and in the private sector, because I know you've got some folks, and to hear from the providers possibly also. With that, I want to announce we do, members, just a reminder, we do have one more meeting. We have a meeting in about a month on December 15th at 10 a.m. Back here in the annex. So you've got one extra meeting for Judiciary this interim. And the agenda should head out sometime next week. I guess there's the 2-week time. There's a couple of things on that agenda. So with that, Chairman, you have anything?
I don't. Thank you. Great.
Thank you. I appreciate it, Director Comstock. Chief, thank you so much. Deputy Chief, thank you. I appreciate it. Happy Thanksgiving, everybody.